panelists for the evening. With this event, we hope to tackle a very important topic. The hashtag #MeToo movement shone a light on the use of non-disclosure agreements, or NDAs, in settling claims of sexual harassment and assault. NDAs are widespread and have become the default strategy in the settlement of human rights cases, including sexual and racial harassment and abuse, and the termination of pregnant employees, just to name a few. LEAF endeavors to ensure through conversations, safe spaces, and advocacy both in and outside of the courtroom that women's liberty, autonomy, bodily, and sexual integrity in both private and public spaces are and remain respected. The money that you donate to LEAF ensures LEAF can continue to effectively research, educate, and litigate equality issues that are important to women and girls, as LEAF has been doing for the past 30 years. If you have not already signed up, please join our mailing list and also register as a member of the LEAF Toronto branch. We will let you know about upcoming events, along with links to different things that we are reading and watching. Without further delay, please allow me to introduce our inspired moderator, who has been working very hard to make this event possible. Paniz Khosroshahy, who is in her third and final year of the JD program at the prestigious University of Toronto Faculty of Law. She also holds an honors Bachelor of Arts in Women's Studies from McGill University. Paniz is passionate about the areas of labor and employment law, discrimination law, feminist legal theory, and critical race theory. Paniz has been a feminist activist for nearly a decade and has previously worked at LEAF National as a fellow with the David Asper Center for Constitutional Studies. With such a balance of skills across various legal realms, but also in the realm of feminism, I cannot think of someone better suited to moderate this event. Please take it away, Paniz.
Thank you so much, Harleen, for that introduction. I'm so excited to be here and grateful to people I've met at LEAF and through LEAF, and who have encouraged me to do this work, to scholars and activists many of them are on this call and on this panel, and very excited to be doing this work now that I'm almost done law school. It's interesting for me to also be having this panel now that I'm almost done, because Mandi, with whom I've been friends for several years now, she was, we'll talk about the lawsuit, but when there was the defamation case that we'll be talking about, when the news of that first came out, I had just started law school. And so it was like the first issue that I was thinking about through my tort classes and contracts classes and whatnot. And it's really cool for me to be coming back to this now that I'm almost done. And so I'll give a brief overview of what we'll be doing tonight. So I'll do a brief introduction of our panelists, and then we'll then start by setting the legal framework, both individual experiences with NDAs that our panelists have, and a broader picture of how these fit within the law. We'll then talk about what happens after you sign an NDA and how they're enforced. And we'll talk about defamation and legislation against legislations on strategic lawsuits against public participation. And we will end with options to address the problems that the panelists have raised. And at the end, we should be able to have a Q&A. So in the chat, you can message Erica Young from LEAF Toronto, who will be moderating those questions and sending them to me. And we'll be able to have some of them answered. And also Zelda is here with us from the UK, which unfortunately it's 11 p.m. there. So you might have to leave us a bit early. So if you'd like questions answered by Zelda, you can also leave your email. And she said that she will be happy to respond to you after. So I'll start with Mandi. Mandi Gray is in the final stages of her PhD at York University in the Department of Sociology. Her dissertation, Cease Desist or Cease Resist, Sexual Violence and Civil Suits, looks at the emerging trend of men accused of sexual violence suing who she refers to as silence breakers, anyone who attempts to hold them accountable for their actions. Professor Julie Macfarlane has spent her adult life teaching in law schools on 4 continents and researching and writing on public interest issues that she believes deserve better public understanding. Julie is Distinguished Professor Emerita at the University of Windsor and the Director of the National Self-Represented Litigants Project. Julie has received many awards for her work and was named to the Order of Canada in 2020. Zelda Perkins is a theater producer and former assistant to Harvey Weinstein. She publicly broke the 20-year silence on her non-disclosure agreement in 2017. In 2018 and 2019, Zelda testified before the UK Parliament to push for change in regulation and legislation around such employment contracts and settlement agreements. She's currently campaigning to change the way NDAs are structured within the law. And last but not least, David Wotherspoon is a partner at the Vancouver office of Dentons with expertise in corporate and commercial disputes, as well as injunctions and anti-pillar orders, defamation and free speech. David recently appeared as intervener counsel representing a coalition of BC women's rights group in the first 2 anti-strategic lawsuit against public participation, or SLAP. Some people don't like that, but anti-SLAP cases heard by the Supreme Court of Canada. He was counsel to the main defendant. He is counsel to the main defendant and Stephen Galloway and AB. And so with that being said, I'll start our questions. So in 2019, the Cornwall inquiry stated that including confidentiality agreements in legal settlements that arise from reports of sexual violence created additional harm to survivors of sexual violence because, quote, for survivors of sexual abuse, having to maintain silence in return for payments can have very negative consequences. So we can start from there and talk about what we mean when we talk about NDAs in the sexual misconduct context. So Julie, if you could start us off and talk to us briefly about what NDAs, how NDAs work in the termination context and where they come from and what they are and how they can be harmful, who they bind, just, yeah. You're muted, yeah.
Now I'm not. Thank you, Paniz. I'm very appreciative of all of the work that you've done to set this up, and I'm really happy to be here and participating in this discussion. So I think that what you want me to do to start this off is to talk a bit about NDAs in the context of the termination of employment, which is also where I have had the most direct experience. But let me just, first of all, I think many people know this, but to be clear, we all know the same thing. NDAs began with a feeling that it was important to protect trade secrets. This is the origin of non-disclosure agreements back in the 1980s, to protect confidential information, especially as the tech boom was developing and there were concerns that people might leave a company and go to another company and take information. So I think it's important to remind ourselves that's how this started, because that is not how they're being used today. Today, NDAs are basically a default in agreements to settle either actual or threatened lawsuits or human rights claims that arise out of employment. So as you referenced, Paniz, the Cornwall report talks about NDAs in the context of agreements with victims of sexual violence. The kind of instance that I'm describing here, and I know that Zelda is going to go on to talk about that first example, where the parties don't include the victim, where the parties are in fact an employer and someone who's about to become an ex-employee, who is being terminated because of sexual or some other form of misconduct. And bear in mind that all the lawyers on the call will know this, these cases are almost never actually tried, because apart from the fact that trial is very expensive, there's a very high burden of just cause that needs to be shown. And so these cases are almost always settled, 95% plus of the time. And the kinds of circumstances would be where there has been a termination that is now being, or an intention to terminate, which a unionized employee is now grieving, or perhaps the employer has said, I'm going to launch an investigation into your conduct, and somebody decides they're simply going to quit and run, and there's some kind of a negotiation then, or it might even happen partway through an investigation. But what happens then is that the employers and the employees, when they sit down to try to make a settlement, they miraculously discover that their interests are really well aligned because they both want silence. The employer doesn't want people to know that someone who they are now investigating and possibly going to terminate for misconduct was part of their institution or part of their workplace. And, you know, I say this in recognition of the fact that in order to get somebody terminated for sexual harassment, that we all know there have been multiple complaints. This is not the first time this has happened. This is a long-running saga, and employers aren't very keen on other people realizing that they've harbored a predator for a long time before finally doing anything about it. So they want silence. And of course, the about-to-be ex-employee wants silence because they want to go on to get another job. So they find themselves ad idem. They find themselves wanting the same thing. And the NDA does that perfectly. It hides the reasons that the employee left the organization, and it effectively means that the employer can, as it's often put, and I think reasonably well put, pass the trash secretively to another institution because neither the employer nor the employee want that information to come out. Now, NDAs also often include a standard letter of recommendation. It also sometimes includes an agreement that everything that has ever been put into a human resources file for that individual will be removed, any complaints, anything that's previously happened. So that is the type of situation in which I've come across NDAs, and I'm going to have some more to say about that later. But the other group that is incredibly important here, and which I'm going to pass over, I think, to Zelda next to talk about, is where you have agreements between victims and the alleged perpetrators. And those victims are told they need to accept some kind of a silence or a gag in order to receive any compensation in that agreement.
Thank you so much, Julie. Yeah, so Zelda, if you want to take that from where Julie left off. Ooh. Okay, sorry.
Thank you. You had me silenced. You were gagging. I thought I got away from that. So yeah, I'm not sure how much everyone here is familiar or not with the details of my story, but just so that everybody knows, when I was put in a situation to sign an NDA, it wasn't presented to me as an NDA, it was presented to me as a damages settlement. I also had not gone into the situation looking for any form of settlement. When Weinstein assaulted my assistant 23 years ago, I constructively dismissed us both from the firm and went to see lawyers, presuming that we would go to court and justice would be served and Weinstein would be tried. I was only 24 at the time, had no understanding of the law, and very naively believed that if I went sort of to the headmaster's office and reported a crime, it would be dealt with correctly. I was disavowed of this the moment I walked through a law firm's office, the law firm that went on to represent me, because they told me straight away that I essentially had I had no legal feet. It was a he said, she said situation, and the disparity of power meant that legally we had nothing, which I found very shocking at the time, as I had sort of presumed that we were all equal in the eyes of the law, and that we would be, you know, that we would go through a court process to decide who was telling the truth or not. I was told that I could take that route if I really chose to, although it would be very difficult because the offence happened in mainland Europe, in Venice. It didn't happen in the UK, so it was out of the British jurisdiction. So we would have had to have gone through the Italian court system. And the first thing my lawyer said to me was, do you have any, do you or your family have any skeletons in your closet? Do you or your family have a lot of wealth? Because if you do choose to go through the criminal process, you will probably lose every penny that you and your family have. You will also lose your reputation. You will be made to look like an insane, unreliable witness. And if there is anything in your past or in your family's past that doesn't want to be newspaper fodder, it will be. So that's quite a frightening thing to be told in your early 20s, when you think that you're potentially reporting a rapist. We were told then that our only option was a damages agreement, because we were agreed that something bad had happened, and that because we couldn't go to court, we had to essentially come to some form of agreement that worked for everybody. And it was represented to us as something standard and normal, and that was the way things should be done. I was incensed by this, because all that I cared about was that Weinstein's behaviour was stopped. So I said, well, if our only choice is an agreement, then the agreement has to be as complex and difficult for him. It has to stop his behaviour. We will pay with our silence if his behaviour is stopped. We felt like that was a fair trade, and that was the only power that we felt we had, and that our lawyers offered us, really. The agreement that we ended up signing ended up being incredibly onerous and extremely unethical, yet our own representation allowed that to happen, as far as I see. And I think one of the things for me, what really has made this battle so important to me, is that it's not so much what Weinstein did, it's the fact that it was actually the law that let us down. The law let us down. Our lawyers let us down, not because they were bad lawyers. They were staying within their guidance. Weinstein's lawyers, once we got to the negotiation stage, were very aggressive, as they should have been, because they were protecting their client. But our lawyers clearly had no incentive to look after our best interest. They saw our best interest as being paid off and sent away silently. They saw that as our best interest. And that's my issue. That's not what they should have seen. And that is still being seen every day. And these agreements are still being made. And when an agreement is silencing people over potentially criminal activity, abusive activity, there is no place for a non-disclosure agreement. That is not what they were designed for. Their use has been perverted. And my agreement, the great thing about my agreement now is that it will always be there in black and white for people to see how harmful they can be. My agreement actually says in black and white that I should use my best endeavours not to aid the police or lawyers if any civil or criminal case was taken against Weinstein. I was not allowed to hold a copy of my agreement. So I wasn't even allowed to reference to see what clauses there were against me. So my lawyer just said to me, you just have to imagine that that part of your life never happened. It's a black hole. That's a pretty awful thing to say to a 24-year-old who's just spent 4 years of their career in a great job, that they have to walk away and pretend that none of that ever happened. And the first step of that for me was trying to go and get another job. How do you explain when you go to a job interview why you have a black hole when everybody knows you worked for Harvey Weinstein? So, the idea that the lawyer's offering you a panacea, here's some money, here's a reference, as Julie said, a standard reference. I didn't have a standard reference. I had a very nice reference from Harvey Weinstein, which rang even more falsely, because why would I have left the company? if I had this glowing reference from Weinstein and all of a sudden I'm looking for a job somewhere else, but I'm not allowed to talk about my time at Miramax working for Weinstein. In our agreement, we also, myself and my colleague, were not allowed to talk to friends, family, doctor, therapist, the HMRC, who are our Inland Revenue, our government tax body. We could talk to a therapist. Sorry, I forgot this, which is a really sweet detail. We could talk to a therapist if the therapist signed a confidentiality agreement before speaking to us. And then if they broke the confidentiality agreement, it would have been my responsibility. So I would have been the one taken to task for them. So, and I was a kid. So we had guns pointing at us from every angle. And we felt criminalized. We felt, once we'd signed that agreement, that if we broke it, we would go to jail. That was how we felt. That was how the lawyers left us feeling, including our own lawyers. And that's what's so shocking about the use of NDAs in these situations, because it allows the perpetrator to continue with complete impunity. The disparity of bargaining power meant that even though Weinstein we had some what seemed like very powerful clauses to stop his behaviour put in the agreement, of course, there was no way for us to follow those up. There was no one to enforce the fact that if he made another agreement in the next 3 years, that he would have to stand down from the company. There was no one to enforce that he went to therapy to make sure that he didn't continue sexually assaulting women. And we had no way of enforcing that. So the clauses that we put in the agreement weren't worth the paper they were written on. Yet we walked away not being able to, for me, it was not so bad, but for my colleague who he attempted to rape, she walked away from this not being able to own her own story. She never told anybody. She hadn't even told her husband up to 2018. So she didn't even tell her husband till 2018. And this happened to her in 1998. She, in fact, tried to kill herself twice in the ensuing years after signing this agreement, because the emotional and psychological toll that these agreements take is something that the legal process is not aware of. The solicitors and lawyers that offer these agreements genuinely have, I think they are now, but have no understanding of the damage that these agreements carry with them. I'm not sure if there was anything else further that you wanted me to bring up in this section.
Yeah, that's great. Thank you so much, Zelda, for sharing that. I'm sure it's not easy to be revisiting these incidents over and over. So at this point, David, I was wondering if you could help us take a step back and situate these NDAs that we talked about within the wider legal context, and tell us how NDAs are used generally in contracts in general, and how do these NDAs that we're talking about fit in within the legal framework?
Yeah, thanks, Paniz. Zelda, I'm sorry that all of that happened to you. It's kind of crushing as a lawyer to hear somebody was so treated so reprehensibly by the law and by lawyers. So it's terrible. I'd like to think nothing like that would happen now, thanks in part to your bravery. I see Julie freaking out at me saying that, but that's what I like to think. So yes, I will I just make a few comments to, so I'm a commercial litigator by training. I've been doing that for about 30 years. I've been involved in a lot of matters involving confidential information, like Julie said at the outset. A lot of it relates to protecting intellectual property information, but that's not all of it. And NDAs, confidentiality agreements, are used all of the time in a whole lot of different circumstances. product development, which is where the IP often comes up, sales of businesses, resolving just business disputes, as Julie said, resolving employment disputes, sexual harassment complaints, and of course, sexual assault complaints, as we know. But, you know, our courts are very much in favor of contracts. We all, you know, the legal system believes in freedom to contract, and that if people sign on to a contract, specifically here, NDAs, the starting place, if you sign it, is that it's enforceable. But that's not the end of the story, of course. There's a lot more to it. But that's, you know, that's the starting point. If you sign it, you should be bound by it. And, you know, I guess there's a lot of different directions I can go with this, Paniz, but one of the points I want to make, you know, well, a couple of points I want to make. One, when Paniz asked me to do this, I thought, that's a terrifying thought, to be the, you know, hashtag sacrificial old gray white guy talking about NDAs and in you know, the sexual assault context. But, you know, so I've done a bunch of reading since Paniz reached out to me, and I was interested to see that there is a debate within about whether or not they should be thrown out holus bolus, or should be maintained, you know, and if you do sign one, when can you walk away from it? So maybe we'll come back to the sort of the balancing act later, but just to your, I think your narrow question, Paniz, about how are they treated in Canada, you know, we do have the concept that, you know, courts won't enforce illegal contracts, and courts won't enforce contracts that are kind of void for public policy reasons. And so, to just focus onto that quickly, if you have a contract that prohibits someone from reporting a crime, the court would not uphold that contract, because that would be void for public policy, because it's interfering with the proper administration of justice. So back to you, Paniz.
Thank you so much, David. Yeah, and we will come back to the enforcement of NDAs. And Mandi, I've had the pleasure of reading parts of your dissertation, and so you do talk about NDAs in your dissertation as well. Wondering what you'd like to add to the conversation that we've been having to now.
Absolutely. So to give some context on my dissertation research, it was looking specifically at defamation lawsuits against who I refer to as silence breakers. So that doesn't necessarily just mean someone who has directly experienced sexual violence, but also bystanders, or people who attempt to hold a man accountable for his behavior, who are then sued for defamation for those actions. So I think it's something I didn't really anticipate when I initiated the research, was how many bystanders were being sued for defamation. And the other thing that came up repeatedly was the non-disclosure agreement. And I have, in my own work, I have decided I've taken issue with the non-disclosure agreement, because with the folks I've talked to, it hasn't been an agreement at all. It's not voluntary, it's not consensual. They have very little say. So I prefer to use the term gag order because of the violence it inflicts. And that is not an agreement. It's often coercive. And I want to reflect the violence inherent within these so-called agreements. And as one participant who I interviewed had said, like, she was literally gagged. She felt like physically sick. And Zelda's case was not an anomaly in terms of the experience she had. And I'm not necessarily seeing this with men in positions of power to the extent of people like Harvey Weinstein, but men of all socioeconomic status. And so I do see this as a recurring issue. And as Zelda had mentioned, in terms of like the inability to talk to anybody about what has happened to you. And what we know from psychological and sociological research is talking about what has occurred is crucial in managing post-traumatic stress disorder. And so therefore, the law is inherently anti-therapeutic, and the extent that the people I interviewed experienced suicidal ideation and the desire to die literally because they were silenced was one of the most surprising findings in my study, and far more so than I had anticipated. And it was often directly linked to the inability to speak about what had happened to them and the fear of legal repercussions because of the cost and the emotional toll of pursuing, having legal action pursued against them. So although my research didn't focus specifically on non-disclosure or gag orders specifically, it was a reoccurring issue, and it was something that many of the participants were fearful of. And the folks who had entered into them, similar to Zelda, felt that legal counsel had told them that unless you sign this, like there's no other option, and felt that legal counsel was not acting in their best interest and had felt that they would not be able to settle the lawsuit without entering in some type of gag order. So I think there's a number of problems with the law, and then also with legal counsel not understanding the unique circumstances of sexual violence and gag orders and the long-term consequences for folks that are coerced into signing them.
Thank you so much, Mandi, and I look forward to coming to your defense in May. And so now talking about what happens when NDAs are signed, going back to Zelda. So you spoke about the NDA that you signed and the process leading up to that. I also wonder if you could take us to the process leading up to breaking the NDA, just both for yourself and for others that have reached out to you, or like you've talked to them at the time, because usually when we come forward, there's a lot of people that reach out and say that similar things have happened to them. And also because it's almost midnight in the UK, if you would like to just jump ahead and say other matters that we might, that you think we should know, please feel free.
Thank you. Yeah, there were a couple of things actually I wanted to pick up on. That firstly, that David said. Thank you, David, for your words. And yeah, I think we would all like to believe that that this wasn't happening anymore, but I'm afraid it's happening, and it's happening regularly and as standard practice. I know that the way I describe what happened to me sounds very, very shocking, but I can tell you that if we actually had to go through a legal process, because I did take both my lawyers and Weinstein's lawyers to the Solicitors Regulatory Authority in the UK for their behaviour, which has ended up really with nothing happening. The SRA did send Allen and Overy, who were the firm that represented Weinstein, to disciplinary tribunal, but funnily enough, the senior partner who was sent to tribunal was too ill to go to tribunal. He's still at work, but he's not well enough to go to tribunal. And my lawyers were let off with a warning letter. My lawyers still will not give me a copy of my agreement, and have actually challenged me to take them to High Court to get any of my papers from them. And this is this is again showing the disparity of bargaining power as a layperson dealing with the legal system. And this is why I feel that the only way to deal with this is not necessarily going after individual lawyers or law firms, because I don't think that that's going to solve anything. The regulators have to change their guidance, not just put out warning notices, and government has to change regulation. We have to help solicitors and attorneys to make the right decisions. At the moment, they think they're making the right decision, and it's in their it's in their benefit to offer non-disclosure agreements because they also get a kickback from that. So, you know, at the moment, there's no incentive to remove an NDA offer because it seems like a good offer. In terms of enforceability, which again is another problem, because my agreement, I discovered long after I broke it, would not have been enforceable if we had gone to court. As you say, it is illegal to have an agreement that says that you can't aid the police. But when I went to my lawyers in 2017, when I broke this agreement and said to them, is there any way I can break this agreement? Is there any weakness in there, considering the fact that Harvey Weinstein, at this point, it was only the beginning of the public exposure of what he'd been up to. It had only been the New York Times story. And my lawyers at that point, again, told me there was nothing I could do, that the agreement was totally watertight and I could not break it. And why would I want to break it? I tried to get advice from other lawyers, but I couldn't because I can't show the agreement to anybody because I don't have it. My lawyers wouldn't show it to anybody because they had signed their own undertaking to Harvey's legal representation that they wouldn't show it to anybody. So it was a double bind. And so there was no way for me to find out whether it was enforceable or not. And, you know, that's my agreement. But for other women who have, or men, this is not just about women, who have signed an agreement like that, the fear factor and the threat of that agreement makes finding out or understanding its enforceability almost impossible, and the risk of testing that enforceability almost impossible. In 2017, I was in the lucky enough position to not give a damn whether it was enforceable or not, because I was prepared to, and it sounds ridiculously dramatic, but I was prepared to go to prison at that point, having heard what I'd been told from the various journalists about Weinstein's continuing behavior over the 20 years since I had last worked for him. And I had to break my agreement with no legal protection or advice. The only advice I had was that I couldn't break it. And the Financial Times, who broke the story, said, we'll do our best to protect you, but we won't be able to stop you going to prison, but we'll be able to get a public campaign to get you out of prison. So, however, when I did break it, I had a QC immediately tell me, publicly say on television that the agreement was totally unenforceable. But I mean, that's a very dramatic version of something that actually is not going to happen to most people. Most people aren't going to have that experience in that position. They're going to be at home with a lot of very threatening legal letters that they don't really understand, that tell them they don't have a leg to stand on. And again, this is the issue, is that NDAs are used very threateningly. And this isn't ethically correct. And the only way to change this, in my view, is a total overhaul from the root. I spent a long time conferencing with many solicitors in the UK about how to make NDAs better, how to have more accountability around the use of NDAs, but to me, it's too complex. And I actually think it's I do think it's binary. I think it's very simple. NDAs cannot be used to gag people over any form of abusive behavior, particularly in the workplace. It's our human right to work in a safe space. And there will always be disparity of power between an employer and an employee who relies on their wage to feed their family and live their life. I think that's all I've got to say about that. Otherwise, I'll go on until 1 o'clock in the morning.
Thank you so much for that. Do you think, are you heading out?
I'll stay on. No, I'll stay on. I'll stay on for a bit.
Okay, great. So now on to you, Julie. So you released information that was under an NDA about a professor at the University of Windsor, where you both worked. So I was wondering if you could tell us about that.
Thank you, Paniz. And I think actually it's going to be really interesting as I tell the story. People will hear the similarities in the experience that I went through and the experience that Zelda went through, even though we're talking about two very different kinds of NDAs here. Hers, as a victim, as someone who was basically being told to shut up by the perpetrator, and mine, which was totally peripheral and actually closer to some of the work that Mandi's doing, as someone else who worked in the same place as the people who made the NDA. So this is actually the first time I'm going to try and tell this story in a very brief way from beginning to end. So I'm a little nervous about that, I will confess, but I'm going to try and do this as well as I can because I think it's really important. And I want to be really clear at the beginning that, the whole point of me telling this story, and it has come out in dribs and drabs over the last few years on CBC, and I've blogged about it. The purpose of telling it is not for people to feel bad for me. I mean, it's a totally miserable and awful story, but that's not why I'm telling it. I'm telling it because I really think that it almost is a perfect example of everything that's wrong with NDAs. And, despite the fact that the NDA that Zelda signed and her friends signed 20 plus years ago, the NDA that's involved in this matter actually has so many similarities. So I really do not think, I did this silently before, but I'll do this now verbally with my mute off. I really do not think, I'm afraid, that lawyers are behaving differently. In fact, I think there's a remarkable similarity, and it is a complicit community to a very large extent. So first of all, I didn't sign an NDA. Hey, I never went near an NDA. I never even saw the NDA. But as a faculty member at the University of Windsor, I started to hear in 2013 complaints from law students about one of my colleagues, Emir Crown. And these were very serious complaints of sexual harassment and other forms of intimidation and bullying and harassment. So myself and some colleagues went to the president and we asked him to suspend Crown and to investigate him, and he did that. So that sounds great. Well, unfortunately, that was the last good thing that happened for a long time. We then waited throughout almost a year as the investigation took place. And I won't go into it here, but if there are other people on the call who've been any part of being close to a university investigation into sexual and other misconduct, you will know that everything that could possibly be done wrong was done wrong. Students weren't offered any support. They weren't guaranteed anonymity. They were told they had to keep quiet about it all. The investigation was secret, so people tried to put posters up in the women's bathrooms about it, which were then torn down. I mean, it was just ludicrous. However, this individual, his behavior was so extreme that, in fact, at the end of that period, when the investigation concluded, although we were not, as complainants, the students and myself, allowed to know the outcome, we managed to figure out that they had sent him an intention to terminate letter because he was now grieving. And instead of returning to the law school, which so many students had been so afraid of him doing, I mean, this was the huge fear that overtook this community for almost a year, that he would come back and then he would retaliate because he was he was very practiced and well known before the investigation for retaliating directly against students. In fact, one student transferred to another school. She was so terrified he would come back. And when she began there that September, all bright-eyed and happy to be at a new law school, suddenly Emir Crown popped up as an adjunct professor because he was suspended from Windsor, and this law school had not been told that, so they'd hired him as an adjunct. I immediately called my president and said, you have to tell this law school, it's a very prestigious law school, why he shouldn't be there. My president refused to do so, told me to shut up about it. And of course, I immediately told my colleagues at this other law school and they immediately removed him. But there's another example of this mania for secrecy that is protecting people. So we finally get to the end of the investigation, and we know they're trying to terminate him. We don't know, precisely what that letter says because we're not allowed to see it. And then I get a call. I'm in Australia. In fact, I was just about to walk on stage to give a keynote, and my dean called me on my cell phone and said, it's over. They had settled with him. And I was so relieved to hear this, because it had been a really appalling almost 18 months by this point for myself and for the student complainants. How I actually managed to publish anything during that period, I can't imagine, because I spent so much time on this whole issue. So I felt relieved. And then the following year, I started to get phone calls from other law schools who were considering him for positions. And the penny dropped. They had no idea, and this was why they were calling me. These were offline reference requests. Why did a tenured professor just leave the University of Windsor? And I realized they gave him a non-disclosure agreement. So I told the truth. I told these individuals the circumstances under which he'd left Windsor. I called my president again and said, what are you doing? And he said, I can't talk to you about this, and hung up, which was, if anything, was the final confirmation I needed that there was an NDA. So I then spent a couple of years working with the university, trying to persuade them that although this was a terrible mistake, that they shouldn't repeat it. The mistake was made, but they should never do this again. And I could not get the university administration to even respond to me. Every door was shut in my face. And, I wouldn't normally mention this, but I was one of the most senior people in the university. Nobody would talk to me about this. And then the CBC published some parts of the story. And miraculously, of course, the next morning, the university wanted to talk to me about NDA policy. So I guess that was effective. But the next thing that happened was that at the beginning of 2019, I was sued by Crown for defamation. I was sued from Trinidad. He obviously wouldn't have done this in Ontario because we could have subpoenaed witnesses and other people could have testified against him. I was actually in hospital at the time, recovering from surgery. And then when I received the actual claim, I was back home recovering, but I was in chemotherapy. So I was pretty ill. So, what would you do if you suddenly got a letter telling you were being sued for defamation for something that you knew was truthful, but you didn't have access to any of the documents? Well, I wrote my employer thinking, obviously, they're going to step in now, surely. But that wasn't what happened. For weeks and weeks, they simply ignored me as I wrote them from a hospital bed. Finally, I got a response from Jeff Berryman, who was the acting provost, asking me in a single one-line email, what is it you expect the university to do? I would have thought the answer to that would be obvious. Release the secret documents, show that I'm telling the truth, and, please take me out of this misery. And then I was told they would have to send the matter to their insurer, which, seems strange there would even be a question mark, since giving a reference is obviously part of my insured activity as a law professor. By the time I heard from the university with the insurer's decision, another one-line email, it was May. And remember, this began in February. And by then I had to take some steps to respond to this action in Trinidad. And I had gathered a little team of friends, lawyers, labor arbitrators, a couple of judges who were helping me, advising me. And I also had a pro bono lawyer, Natalie McDonald, who is a former student. So when they turned me down, which was ludicrous, of course, we had to take them to Superior Court to compel them to defend me. And I have to say, watching the presentations in Superior Court that morning, when my lawyer explains what happened and the fact that I was responding to a reference with, a truthful information about why somebody left, and then watching the insurer's lawyer present, I actually felt sorry for him because he had nothing to argue here. And the judge made it very clear very quickly that he didn't have anything to argue. So that was a slam dunk. We got a decision saying, yes, of course, she was acting in the course of her employment. And yes, you are compelled to defend her. So I was assigned a lawyer by the insurance company, who I repeatedly asked, was he going to put those secret documents into the evidence in Trinidad to show that I was telling the truth? And in the meantime, this was halfway now through that year, I decided last year I couldn't stay at the university. I'd been there for 25, 27 or some years. I just couldn't stay there. I was disgusted. So I negotiated my exit. There were also reprisals starting to happen. Then the trial took place in Trinidad, and I discovered the outcome of the trial because Crown posted on the University of Windsor Law School's Facebook page. This is how I found out about the result of the trial, describing me as a racist and as a woman scorned, which is kind of an interesting little additional throwaway misogynistic comment that he would make about someone with whom I've never had a conversation with this man ever. So I'm a woman scorned and a racist, and I've made all of this up, is what he said. And as an aside, it took me almost 2 weeks to get the University of Windsor to take this post down, describing me as a racist. So then I read the judge's decision, and the judge's decision in Trinidad said that no evidence had been entered. The penny starts to drop again. This is sort of a story of a lot of naivete on the part of a law professor, the way that this is unfolded. They didn't enter any evidence, and they didn't challenge the evidence in cross-examination. So basically they threw the case. So to bring you up to the present time, I then received, and my lawyer, Natalie MacDonald, received from a third party, finally, a couple of months later, the documents we've been trying to get hold of all the time. We got the letter of termination, which is here, 2 pages long. It's now in the public record because this was filed with motion materials in the Superior Court. It's 2 pages long, and I'm just going to read you. It was even worse than I imagined it was going to be. I'm just going to read you a small section. You have repeatedly engaged in harassment. Your misconduct has served to intimidate students and create an unsafe learning environment for them. You have shown little to no appreciation for the impact of your misconduct and have accepted little to no responsibility for your actions. So they were terminating him. I also got the settlement agreement that was made after that letter was sent to him, which, by the way, my union also signed on to. And there were a couple of surprises in this. Not the fact that they gave him a non-disclosure agreement, or even the fact that they also agreed to take every record of him out of his HR files. There was also a non-reprisal clause in here. And so this kind of reminds me of some of what Zelda was talking about before, about the clauses in her agreement, which were supposedly going to make Weinstein do something about his behavior. But of course, she couldn't enforce them. Well, I couldn't enforce the non-reprisal clause against me. And this is specifically here in this agreement, because I had no idea that it was there, and neither did any of the students, who, of course, once I was sued, then spent, a sleepless year wondering whether he was going to come after them as well. And then, just for, and by the way, the severance they gave him was 6 times what they'd negotiated with me a couple of months earlier. So that was kind of another little cherry on top. But then I think maybe the best part of all is his letter of recommendation, which calls out what a great teacher he is and has so many publications, et cetera, et cetera. So that's what they were sending out. So here's 2 thoughts that I want to end this with. One is that, I have been through a lot of difficult things in my life. And, some of the people on this call probably know that, because I've been very public about myself as a survivor of sexual violence. And I also have cancer, which of course the university has known throughout this. And I think they were probably, given that I was very sick when I was originally sued for defamation, they were probably counting on me not being around any longer by now. So unfortunately I am, unfortunately for them. But this really has been one of the worst experiences of my whole life, and although it's a different experience in terms of my proximity to the NDA than the one that Zelda has described, and the women who've been interviewed by Mandi have described. This has been an absolutely horrifyingly appalling, almost unendurable experience. And the second thing I want to say, and my final point, is that the thing that really bugs me about all of this is also that it's also incredibly stupid. I mean, what was it the University of Windsor thought was going to happen when people started asking, why did he leave? Well, obviously what they thought was going to happen was that everybody else would lie or dissemble. So unless everybody had received a memo saying, by the way, if anybody asks you about Amir Crown, you're not to say anything about anything he actually did. Like, what did they think was going to happen here? And I know for a fact that universities across Canada are using NDAs still in these circumstances. Thanks, Paniz.
Yeah, thank you, Julie. There's like a lot there that I can talk about, but I would say that I'm very appreciative of you taking a stance for your students, just because I've seen time and again how professors, feminist professors, they don't. And I mean, like Mandi and I, that's how we met. Like we were part of, like we were pushing for all these sexual assault policies and centers to be created. And that was all over the media in the mid 2010s. And now it's like kind of fallen off the agenda because look at all these shiny policies that all these universities have, but they're not working. Like I'm writing a paper about like how they're very similar to like human resources in the sense that they're not there for students. They are there for the university to manage the situation. They're employed by the university, and students, the state of the student movement is miserable right now, but like students, like, yeah, I mean, there's the student union, but they don't advocate on behalf of students. They will not bring a human rights complaint for you if something goes wrong. They're like, students have no one to liaise on behalf of them to the administration. And these centers are just like, and policies, they're just entrenching, in my opinion, the university administrators power, and to just say like, oh, sexual assault, here's our policy, like goodbye. Anyway, so thank you so much, Julie. And with that, David, I was wondering, so if we could again take a step back with the experiences that both Zelda and Julie described, and if you could place those again for us in the, within the broader legal context, and how, just to go back to the conversation that you started earlier about in what situations these NDAs are enforceable or not. Oh, there
we go, finally. One of the things I want to do in stepping back is first of all, respond to Julie's comment that lawyers are complicit. There are some excellent lawyers on this call who I think don't deserve to be called complicit in promoting the use of NDAs. So in lawyers across the country and around the world, but I'll just speak for Canada, have codes of conduct that they have to comply with. And it's, I'm not saying every lawyer does, but there are standards. And it's unfortunate, Zelda, that for your experience, and Julie, it sounds like you had some bad experiences, but knowing a number of the lawyers who work in this space, and some of whom are on this call, there are some great people working in the space to make sure that victims' rights are addressed, and are addressed properly and fairly. I've been involved in a number of cases over the years. I've represented a woman who was a participant in a BDSM dungeon getting sued. I've sued a dominatrix. I've seen a whole variety of circumstances where people would prefer not to have their conduct become public, a lot of it consensual. And when when you think about NDAs, I think you need to recognize that there are a variety of circumstances where they're inappropriate, and there are a variety of circumstances where they're completely appropriate. And to me, it's important to recognize that if there's a victim, and I'm going to just say that if people are engaged in a BDSM dungeon, they're doing that by consent. And as a general principle, that is a confidential process, and they choose to keep that confidential. But there certainly are other circumstances where power imbalance or conflicting versions of events, where the victim may still choose in resolving disputes to keep that private. And I think the victim needs to have that right to choose. And that you can't say as a general proposition, NDA should be bad or should be unenforceable. But in the context of that, I'm assuming that the victim has access to good legal advice, and that the agreement is fair and proper, well negotiated, and then that should be the victim's choice. And part of what you're choosing is to avoid the litigation. Presumably there's some compensation in there, but all of that has to be part of the package. And I think with good legal advice, so that the victim can make an informed choice, not under pressure like Zelda was under. And so I think I think that it's not an automatic NDAs in this context are bad. I think it's more contextual than that. So some of the arguments against, of course, and I think the strongest argument against NDAs is that they enable serial predation. And, I think we'll all agree that's a terrible thing and that shouldn't happen. It keeps misconduct secret. It may bar victims from reporting crimes, and it impairs victims' ability to connect with one another. And I think there's a lot of value and benefit from that. The arguments in favor of NDAs, it expands victims' choice, as I mentioned. It empowers victims by giving them the option to remain anonymous if they choose, creates certainty, avoids publicity, it avoids the burden of a trial, and it may enable compensation. So to me, it's a complicated issue that you need to. The bottom line is, I think it's about the victim and what the victim chooses. And if the victim prefers anonymity, privacy, then they should get a good lawyer and help them achieve that if that's their choice.
And could you also talk to us about the public policy, like the enforcement as well?
Yeah, absolutely. And I touched on this earlier, but so if you are subject to an NDA and it doesn't have a carve out, and you want to honor your NDA, what can you say? I find it shocking to think you couldn't talk to a therapist. There are often carve-outs where you can, in confidentiality agreements, you can obtain legal advice, you can obtain tax advice, you can report to regulatory authorities, and they should also have, in this context, you can talk to a therapist, all you want. Paniz, I forgot your question already, sorry.
Yeah, just the enforcement that we talked about for illegality in public policy.
Yeah, so, in current Canadian law, if you have signed an NDA that says you cannot report to the police, I think you can feel very confident that absolutely you can, with impunity. If there's a crime involved, you'd want to take legal advice. If it's a conflicting version of events, and one thinks there's consent and one thinks there wasn't, well, is that a crime? It's going to depend on the circumstances, and you'll want to be a little more cautious about that. But I think there are It's not a black and white issue. But the other thing is, and I'm not giving legal advice here, but just to bear in mind, if someone does choose to breach their NDA, what's the, well, we'll just say what's he going to do about it? You go public. Is he going to sue you for the money back? Probably not. Presumably he wants to just go and hide somewhere. So there may be no practical consequences for breaching it. But bear in mind, I'm not giving you legal advice to breach your NDAs.
Thank you so much. So Julie, did you wanna say something? Because yes, when David pushed back, or would you like to, because we are talking about like lawyer regulation and such, or do you wanna speak at that time?
Right. Yeah, I do. I have a couple of things I want to say about that, but I also want to make two quick points that I think are really important, because I think otherwise we're getting the waters really muddied here. First of all, we're talking about NDAs here as if they always have to be mutual. But the real point here is that you can still protect the victim's identity. You can still give privacy to a victim in all the ways that David was just talking about without protecting the perpetrator or the party on the other side. It doesn't always have to be mutual. It's called a confidentiality clause. And we teach that in first-year law school. So there's been this idea created that somehow that, unless a victim agrees to be silent, you can't keep anything silent on the other side, and they'll have to sell their silence. But of course, you can achieve what victims want, and only one part of what victims want is privacy. And I also have to say that I personally believe that the protection of the larger public overrides a victim's need for privacy in this situation as well, because I do believe that allowing people to go on and serially predate and harass and bully and intimidate is wrong. And I'm not sure that any one person has the right to say they don't want them to do that. And they don't need that if the confidentiality is about their own identity. So that's the first thing I want to say. The second is that we haven't yet used the word non-disparagement clauses here, which I think is important, because these are also a huge fashion. They are enormously broad, as anybody who's ever used one or been asked to sign one will know. And they are also a way of silencing people. And in their final communication with me, the University of Windsor actually told me they wanted me to sign a non-disparagement clause, which is kind of sweet in a way, when you think about how ludicrous that is. And that non-disparagement clause wasn't going to apply to them disparaging me. It was just going to apply for me disparaging them, which basically meant saying anything about them that they didn't like. In other words, everything that I've said tonight. But let me come to your question, Paniz. I really feel like this victim rights thing is not well understood. And I'd love to be able to say more about that, but I want to come to your question here. I think that there are three basic routes here that we can use to try to find a solution.
Sorry, could we say
go ahead.
that for after we talk about defamation? And David, if you wanted to say something in response to that, if we can come at the end to the how to move forward piece, we'll do that. So now I was wondering, so if we're talking about NDAs, I thought that it's also important to talk about the defamation and anti-SLAPP legislation, because you don't, that's another way that you can be made to keep quiet about issues, about these issues. And so the people that have been affected by the abuse, as well as their supporters, as well as the media. And so Mandi, that's literally your dissertation. So if you want to just tell us about these lawsuits that you have researched about.
Yeah, for sure. Thank you. I will defer to David and Julie for the legal side of things. So I approach defamation lawsuits from a sociological perspective. What I think is so interesting about defamation is, like, defamation is the body of law solely with the purpose of protecting reputation. Reputation is inherently sociological. It is what people perceive of us. It is socially constructed based on various social institutions, where you went to school, where you work. And yet defamation and the concept of reputation hasn't really been looked at in the legal literature mostly, but not really that at all in the sociological literature. How I came to this topic of defamation suits was in 2016. I was doing a lot of activism work, as you had mentioned, Paniz, and two different women, young women who didn't know one another, within a couple of weeks had told me that they were actually one woman was being sued and criminally charged for making a false report. She was later acquitted at trial. And then another young woman had, felt like she was pressured into the gag order because she was young. Similar to what David was saying, she was worried about her parents knowing. And so I asked Joanna Birnbaum, who's a lawyer in Toronto, if this was common. Like I didn't know it was even possible. When I first came forward in 2015, the legal advice I received, which was actually not great legal advice, was as long as you're telling the truth, you can't be sued, which really misrepresented the defense of truth. And so I had this idea. And so when I was hearing all these lawsuits, I asked Joanna, and she said she was representing a number of women who were being sued for different things. And one common misconception that I would like to clear up is that when I talk about my research, people often assume that it's all these women jumping on Twitter, me too, naming names. Very rarely what's been happening. So what I've been seeing in my research is that, and they are predominantly women, they are taking the steps that they are told are the right things to do. Reporting to human resources, reporting to campus administration, reporting to the police. As we know, those reports typically go nowhere, or she gets the result that we're supposed to desire. He loses his job, as we saw in Julie's case or in the Galloway case, the so-called good outcomes. And she is then held personally responsible for the damage that has done to his reputation. And there's like legal reasons for why that happens within defamation law that I don't want to get into. But that is what I've been seeing. And that started in 2016. The earliest case that I identified occurred in the early 80s. And as Constance Backhouse reminded me, just because I can't find any record of it doesn't mean it wasn't happening before that. However, it was, and it's very similar to what we're seeing today. It was Carleton journalism students worried about sexism and sexual harassment that they were witnessing within the department. They held a little conference talking about faculty and sexual harassment. And this is interesting. The women who organized the conference were sued for not naming names because it painted all faculty with a broad brush as sexual harassers. So I use that case to demonstrate that we're, wrong if we name names, we're wrong if we don't name names. And it's how these defamation suits kind of emerged within this space. And so I started this research in 2016, and just like by total coincidence, the day I finished my dissertation proposal about to start the research was the day I sat down in class and Joanna Birnbaum called me on the phone and said, "Hey, Mandy, you're getting sued." And allegedly I was being sued for posting a photo of myself in a gallery, among other things. And so I've been doing this dissertation while simultaneously being sued myself. And I think, like Julie said, I too have been through, the criminal legal trial. I've gone through the human rights tribunal, where I was also asked to sign a non-disparagement. So I thought that I didn't anticipate being sued as feeling as horrific as it does. And that's why I think this project has taken on such importance within my life, and bringing forward this issue just about defamation law and what we should be able to say, and retaliation. And the other thing I'll just say before I stop talking about the lawsuits is that another really important finding from my study was that these men don't just sue. They often will use multiple complaints processes, as we saw with Julie. This is not unique. It's the human resources. I had numerous people, and this was also very concerning to me, was the number of participants that were not only sued, they had the police calling them, saying that they were being investigated for criminal harassment. What we know within the VAW sector is getting the police to respond to any type of violence against women is very challenging. Yet to have that sheer number of women tell me that they were told that the police were investigating them for criminal harassment because they were saying mean things about men on the internet was, again, a really shocking finding from my research, and demonstrated that the lawsuit is often just one of multiple complaint processes that are initiated in order to like wear people down. And that's why I do think that these often are like what is referred to as abusive litigation within the family law literature is being replicated here, of just like, there's just so many processes ongoing that it just wears people down to the point where they want to give up and don't want to keep fighting. So that's my sociological introduction to what I've seen in specific to defamation lawsuits where there are allegations of sexual violence, and the others can fill you in on the legal elements of defamation law.
Thank you, Mandy. So yeah, so David, if you'd like to fill in that legal piece, and also in terms of the cases that you've worked on yourself, and also just in generally, and also talk about anti-SLAPP again, like in general. Also in I read the factum that you wrote for the BC Coalition at the intervention at the Supreme Court. So if you'd like to talk to us about that as well, that would be great.
Happy to do that, and if I drone on too much about legal issues, hopefully this is a good audience for that, but I'll try not to put anybody to sleep. So if a plaintiff in a defamation suit actually has a pretty easy task. They have to prove that something was published, as in spoken to a third party or written to a third party or on the internet. So that's published, that it's about the plaintiff. So if you name the plaintiff, that's pretty easy. And then the third step is that it was actually defamatory. And something is defamatory if it would lead right-thinking members of the community to hold the plaintiff in hatred, ridicule, or contempt. Sort of my favorite definition, because it's the one I happen to have memorized along the way. It's more than something that's insulting, but it's really still not a very high burden. And that's all a plaintiff has to prove to make out a case in defamation. Then it's over to a defendant to prove a number of possible defenses. One is truth. I'll come to the others in a second, but truth in the context of, he raped me, no, I didn't, she's lying, is a very difficult issue to prove. Very, very difficult issue, because you got a court with, how do I know which one is telling the truth? And it's almost impossible for a judge. But there are lots of other defenses. One is absolute privilege. If you say something in a court while the court's in session, can't get sued for that. Same thing in the parliament or legislature. Qualified privilege, if you say something where there's a duty to speak, whether it be legal, social, or moral duty, and there's a corresponding duty to receive the information, then you might be subject to privilege. You may be entitled to have said that without and still have that defense, as long as you weren't acting maliciously. Fair comment. So our courts recognize the importance of free speech, and that we should all be able to express our opinions freely on issues of public interest, so long as those opinions are based on facts that are true. Then you can actually be very aggressive in your expression of your opinions. So those are the main ones that come up in the communications issue or world. There's responsible communication. So if you publish something and you've gone to some trouble to ensure that it's true and accurate, and you give the person you're writing about an opportunity to comment, then you may have a responsible communication defense. How's that for a quick overview, Paniz?
Yes, that's great. And if you also wanted to tell us about anti-SLAPP.
Sure. So Ontario, and about 5 years ago, implemented anti-SLAPP legislation, and British Columbia implemented almost word for word the same legislation a couple of years ago. And what it does is recognize the significance of expression in our free and democratic society, and recognizes that there are some lawsuits that inappropriately impair the right of expression. And so you can apply to have a case dismissed without ever going to trial under this legislation. In BC, it's called the Protection of Public Participation Act, or PPPA. You can apply if you can demonstrate that the litigation relates to an expression that's on a matter of public interest. If you can do that, and I'm just reading from the legislation here, the court must make a dismissal order unless the respondent, in this case the plaintiff, can demonstrate to the court there are grounds to believe the proceeding has substantial merit and that there is no valid defense. And so if it's a matter of an expression on an issue of public interest, and the plaintiff can show there's ground to believe the claim has substantial merit and the defendant has no valid defense, then you turn over to a weighing exercise. And the Supreme Court of Canada in recent decision said this is the crux of the legislation. And you compare the harm to the plaintiff, not always suing for defamation, but often suing for defamation. And does that harm that will flow from the expression outweigh the public interest in protecting that expression? And so I had the good fortune to appear on behalf of West Coast Leaf and 3 other women's rights groups in the 2 cases that went to the Supreme Court of Canada a year ago, November, and the decision came down, I think, in October of 2020. And what we argued was that when they were interpreting the legislation, they needed to be mindful that there are a number of people, mostly women, being sued for reporting sexualized violence, and that they should interpret the SLAPP legislation, the anti-SLAPP legislation, in a way that encourages rather than discourages reporting of sexualized violence. And if you care to go look it up, the Points decision, paragraph 80, sets out a number of factors that the courts should consider when considering these issues, which touch on, which I think kind of reflect part of what we were arguing. And they've said, think about these things. What is the expression really about? And so we are, and Paniz touched on this, I represent, or not just I, but Joanna Birnbaum, who's in Toronto, and then I and some others are working hard to bring a anti-SLAPP application on behalf of AB in the Galloway case. Mandi's involved in that case. And we're all seeking to dismiss the claim pursuant to this PPPA legislation. We're all working busily these days because our arguments are all due next week, and we have an 8-day hearing starting on April 6th. So as far as I know, it'll be the largest application of its kind in Canada so far under this new legislation.
I'm sure I will be watching for that case. Thank you for that, David. So at this point, I want to go back to Julie to talk about what all of you on the panel think that we can do in order to address the various harms and issues that arise from the use of NDAs of the sexual misconduct context. So Julie, if you'd like to start us off.
Certainly, thank you, Paniz. I am very familiar with this argument that we have to allow NDAs in certain circumstances because it's a victim's right. And I'm not going to claim that I have this all figured out yet, but I've spent a lot of time talking to people about this, including people who signed NDAs and regretted it, which as far as I can see is basically everybody. And also to other lawyers in the last several months, because Zelda and I are getting ready to launch an international campaign with allies in the UK, Canada, the United States, Australia, Ireland. That's so far. Hopefully there'll be more. And the conclusion that I have come to is, as I've already said, there is a public interest that outweighs a victim's exception. If the student who I had arranged to be transferred to the other law school because she was so terrified that Crown would come back to Windsor, and then he popped up in the prestigious law school that she was now in, if she had told me she didn't want me to tell anyone, and I already had thought about this when it happened because I got her message when I was traveling, if she told me she didn't want me to do anything, I would have still had to say something to the law school administration because he is a danger. He is a danger. And I mean, we have to get over this idea that NDAs are being given to people who only do this once. I mean, please, do we really have to talk about that? We know that people who do this do it over and over again. And that's why sending them somewhere else allows them to do it again. And I'm also very sure that we're smart people and we can figure out a way to protect victims and to protect future employers without necessarily giving everybody a gag. I mean, this idea that if there's a gag, it has to be everybody is ludicrous. It doesn't need to be like that. It can be something that is tailored for the particular circumstances to protect an individual. And I really believe that, that we're going to have to face the fact that other than in the circumstances in which they were originally developed, confidential, private information in business, NDAs are really toxic now. And part of the reason they're toxic is because, and I'm sorry to have to be this direct about it, but I think the conversation so far requires me to be this direct. They are absolutely default. This isn't something that's unusual. This is something that basically every lawyer is going to do at some point. And some of them will say, which I would greatly welcome anyone who's on this call saying, I feel badly about it sometimes, I'm uncomfortable with it. But, trying to parse it down to, you can give an NDA to somebody who uses the following racial epithets, but not these racial epithets. Or you can give an NDA to someone whose sexual harassment is outside clothing, but not to people who are inside clothing. I mean, this is ludicrous. We know that what these are doing are protecting people. So my feeling about solutions is that there does need to be a ban on NDAs in circumstances where there has been sexual misconduct, sexual harassment, abuse, bullying, racism, harassment, things that we do not want to go on happening. That is the point. And which if people are doing that, they're not doing it for the first time. There's already, those of us who work in this area know there's already a filing cabinet of complaints about them by the time it finally reaches the light of day. So I think we do that principally. The best route is going to be through legislation. And we have a couple of models now. There was legislation actually being proposed in England and Wales before the current government took over, which Zelda was involved with, but that's been shelved now. But California, I think, has the best model so far. And they initially in 2018 banned NDAs in cases involving sexual harassment and sexual misconduct. And they are now amending that to include racial discrimination and harassment. And that will be debated towards the end of this month. We might get there through case law. And I'm, really, really interested and will be following, very closely what's happening in the SLAPP suits. I think that's a really interesting development. And we've seen some case law in the United States that's starting to get into fleshing out what this public policy idea is. And it seems to be being seen as somewhat an issue where there are safety issues for third parties. So exactly the circumstances that we've been talking about. But we haven't really, we started to see some whiffs of that in Canada, but we don't have that really established yet. And it's just being established in the US. And the third way that I would really like to see us start to tackle this, and there is one example so far of this having happened, and that's in England and Wales, and is actually also largely due to Zelda's work. I would like to see the regulatory bodies, the law societies, as David quite rightly said, the law societies, do require lawyers to follow a code of conduct. Unfortunately, sometimes that code of conduct is couched in extremely vague and woozy terms. So it's difficult to actually know what it really means or how much effect it has. But in the United Kingdom, the Solicitors Regulatory Authority has now issued very specific guidance. It's framed as a warning to solicitors using NDAs, and talks, for example, about the fact that they should never use them to stop people talking to family, friends, and therapists, which is still happening. I know this is still happening, that they should not use them where there is a gross inequality of bargaining powers, that they should take care to make sure that their clients really understand. I don't know how you enforce that, but that is one of the requirements as well. And that they should be extremely cautious about their use. And that only goes so far. It obviously hasn't resulted in too much disciplinary action yet, as Zelda mentioned earlier on. But I think that having the law society step up and say, this is not something that we believe that lawyers should do on a regular default day-to-day basis, because that is exactly what they're doing at the moment.
Yeah, thank you so much, Julie, for that. So so at this point, I'd ask either Mandi or David to jump in. And also, we do have 2 questions about what Julie was discussing in the area of legal ethics. So what the rules of professional conduct could do, and I believe the question is that maybe if provisions, for example, such as integrity, integrity and duty to represent, or those things that I learned in legal ethics last semester, if those can be sufficient, or if not, what other regulations law societies specifically could be implementing, and also if there is overlap with whistleblowing legislation. So so Mandi and David, if you wanted to jump in with those questions also in mind, if you wanted to respond to those.
I'll just say I don't have a lot of faith in regulatory bodies. I'll give a very brief example, then I'll move on to what I wanted to actually say. So for example, as some of you may know, I went through a very high profile criminal sexual assault case. In the duration, as those of you who went to law school know, the Crown doesn't represent the victim. So I was unrepresented in the courtroom, and I endured a lot of questions that would, in the eyes of the law, violate the rape shield provisions in terms of asking me about my sexual history, asking me about questions that had to do with what I had talked about with my therapist, despite both of those applications being denied by the judge. While the Crown did object on a number of occasions, she didn't always, and she explained to me that it wasn't her role to object to every line of questioning because it wouldn't look good, or the judge would get annoyed, whatever. And on a number of occasions, I actually had to ask the judge myself if I even had to answer the questions because they were so gross. I talked to a few trusted people about whether it would be worthwhile to report this lawyer to the Law Society for her conduct. And pretty much every person I talked to said, don't waste your time. What they're going to say is, she's young, she's a new lawyer, and this is just zealous advocacy, kind of like so lawyers speak. And I was actually pretty surprised, because to me, it was so obvious, like, this is wrong, this is bad. And of course, that's just an anecdotal example. But if I don't know, I don't have a lot of faith in legal remedy for this larger social issue of victim blaming and this common belief that women are liars. And that also leads me to my commentary on the anti-SLAPP legislation that David had laid out for everybody. Obviously, I'm biased in that I really want the lawsuit against me to be dismissed as a SLAPP. I think there's going to be some very real challenges I think that we will be able to pass the public interest hurdle. And I'm not speaking just specifically about Galloway case, I'm talking about sexual violence cases in general. I really worry about this substantial merit hurdle. I think it'll be really challenging in cases of sexual violence because, as David was talking about, when these issues emerge in terms of sexual violence, they're often in private, and like, how do you convey to a judge who may not have a very in-depth understanding of sexual violence? I think it's going to be very challenging to get past that final hurdle. And I'm obviously not the lawyer in the room, so I'll defer to others. But the other barrier I see is that it's expensive, and like it's incredibly expensive. And I was actually just chatting with one of the people I had interviewed, because when I had interviewed her 2 years ago, she was like, I don't have 30,000 to take this to trial. I wanted to follow up with my dissertation findings with her, and we were laughing because she's like, I was so naive, 30,000, like more like 200,000. So they're just like, in terms of moving forward with these applications, I think there's also that financial burden. The requirement to submit an affidavit has also raised some issues for cases in sexual violence as well, that I'm not going to get into here, but these are just different things to think through. So and another thing I wanted to mention, if anyone is interested, I'll put it in the chat. I've been raising money to help AB, who is David's client in the Galloway case, who's the main complainant. And I'm also raising funds to help a woman at Yukon College who was sued by the instructor that she reported. And as David had mentioned, we will be moving forward with the anti-SLAPP motion in early April with the Galloway case. So if folks can donate, that would be really helpful for all the women involved. And in terms of moving forward, although I don't have a ton of faith within the legal system to remedy a very much social problem, one thing I do think we should look to, and this is specifically to defamation lawsuits, is expanding absolute privilege to all reports of sexual assault to a formal institution, whether that's the police or university, for example. The other recommendation I would have is specific to the university space, and this is like, as Julie's case had demonstrated, for faculty being insured, but I think that should potentially be expanded to all university community members. If you are going to make a formal report to your university, which the universities are encouraging people to do, they cannot bear the burden alone to respond to a lawsuit, especially for undergraduate students who do not have those same resources of the union, for example. And that's always something I was very grateful for when I was assaulted, was I was a unionized member. Without that union support, I don't know how I would have taken on the university in the way that I did. So that's my very long-winded response to different pieces that I think are compelling, or I hope that encourage further discussion for folks either today or in the future.
I want to jump in just very quickly. I think Julie's sort of in the queue next, but to the extent that Mandi is raising funds for the AB litigation, it's not to pay my fees. We're doing it pro bono.
Thank you for that clarification,
Okay.
David.
David, it is your turn actually, so you can go. You should go ahead. And also, if yes, just like for how you think we can move forward, but also again, like so the questions that we received were about like legal ethics, so like legal regulation as already exists, whether that can apply or whether law societies can do like further regulation, and also the overlap with whistleblowing protection, or like whatever else that you'd like to note in closing.
I don't know that more regulation is going to add any value. I think more education for lawyers and judges will likely add value. One of the points that we have made in the past and will continue to make is that over the decades, we have seen a number of statements from the Supreme Court of Canada and from other courts about how we all need to do better, in issues around sexualized violence, but we don't seem to be doing any better. I was happy to see the Supreme Court of Canada recognize that in R and Barton in 2019. And that formed part of our submissions. It will certainly form part of our submissions in the AB Galloway hearing in a couple of weeks. And I think we all just need to keep hammering away at that point. There are a lot of problems, and we all need to work collectively to do better. But just to get back to the NDA, I don't think a blanket ban on NDAs is really the solution, because it takes a choice away from the victim, and I don't think that's a fair thing to do. Make them better, fix the problems with them, make sure the victim has proper representation, but I don't think a blanket ban is the solution.
Thank you, David. So just a reminder that you can send your questions to Erica, because we do have time now. One question that I would like to ask.
Can I just say one thing
sure,
about ethics? Sorry, I just want to, I agree with David that education is likely to be more effective than regulation, but I think that regulation and I've written about this in the past, is symbolic. It's a way of saying we recognize that there are risks here. We recognize that there are dangers here. And but having said that, one other thing I will share is that the letter that I read to you from, I read you a small piece of the letter of termination, of intention to terminate, which described harassment, intimidation, misconduct, etc. This individual, Crown, has a license to practice in Ontario. In fact, one of the places that he's harassed me from is his so-called legal office in a Holiday Inn somewhere in Ontario. I showed that letter about him, that 2-page letter, to I won't say who, but a very, very senior person in the Law Society, who told me that there was nothing in the Law Society's code of conduct that would make this rise to the level of a complaint. So I think that people should just kind of absorb that information. And the reason was because he wasn't intimidating, harassing, or bullying as a lawyer. He was doing it as a law professor. And apparently, if you do it as a law professor, that doesn't count. So I think, there is a little bit of a lacuna there in the regulatory framework. But I'll let you get back to your question, Paniz.
So I have two questions. One is something that so one I was wondering for you and Mandi could speak to, because you, Julie, you're doing the international campaign against NDAs, and so I was wondering if you could speak about, either of you could speak about what you see in the international importance of doing feminist advocacy. How and why are you doing it in an international scale? Because the laws are different. I'm curious about that. And also another question that we received is that, can a victim file a defamation suit against an abuser who attempts to disparage them in public? So Julie, if you want to speak to the first question, and then the second question we'll maybe leave it for David. We'll see.
Well, I'm sure that Mandi can speak to the whole idea of international feminist advocacy just as well and probably better than I can. But we know that, because, this was never something I kind of planned to get involved in. As maybe some people on the call know, there are a lot of other things that I'm working on and have worked on, but this one just kind of landed on my head. And in the course of that, I have talked to many people. I have a lot of roots still in the United Kingdom. I've gotten to know Zelda, obviously, but many other people, lawyers and legal scholars there, and also in the United States, where I've done quite a lot of speaking about this, and I've done some writing and publishing there. And, you know, basically, this is a problem that everywhere is trying to figure out. It's not like there really is a clear path to a solution here, although, as I mentioned, California, I mean, we're starting to see some, and I think we can figure some out. But the actual problem is the same everywhere. I was on a call a few days ago with people from the Republic of Ireland, same issue, same problem. So I think that we are seeing this coming up over and over again. Just this week, the Senate in Canada introduced a new internal sexual harassment policy, which has mandatory NDAs for everybody. And they do include, by the way, just in case we thought it had fallen out of fashion, family and friends, if you go and read the small print. So, you know, we're all still doing this. And I think we need to collectively do it better, do it differently. And so I'm hoping that the international level at which we can connect people, and we are currently connecting people, and I'd be delighted to hear from anybody who's on this call today. I think that is going to be a way to really raise voices. And I believe that we're going to look back in 5 or 10 years and think, do you remember when we used to let people do that? I mean, I do believe this is attainable, and I do believe it's our responsibility to do it.
And so we do need to wrap up soon. Mandi, if you wanted to add anything to what Julie said, and then I'll let David maybe like speak to the last question.
And I'll also note that I'll just refer, because you asked about whether people who can sue for defamation, they're the person who has abused them. That was one of the questions as well.
Yeah.
And it's interesting because actually in 2020, there was a story in the New York Times about defamation law as the new battleground for sexual violence, because that's what's been happening in the United States. I think I refer to them as liar lawsuits. So she comes forward with an allegation and he says she's a liar. She sues him for defamation. Maybe David has seen this happen more because he's a lawyer, but I haven't seen this happen in Canada. And my hypothesis as to why is that because the statute of limitations in Canada is much broader than what it is in the United States. In the United States, it's very narrow. So I think that the people I've talked to that have initiated legal action, it's been for the damages related to the sexual violence, as opposed to calling her a liar. I could be totally off on that, but that's just from my conversations I've had with people in the Canadian context. With that being said, as the New York Times said, defamation law is the new battleground for sexual violence. I have also, as part of my dissertation, I did a media analysis. So what I did was from 2015 to 2019, I looked at every single news article about defamation, which was really exciting and fun. And I looked at it on a global scale. And then I only looked at lawsuits initiated by men against, or someone accused of sexual violence. And one finding was, like Julie said, this is happening international, everywhere, India, Japan, like America, there was no country I didn't find this happening. There's a lot of lawsuits happening in Bollywood, in India, for example, for similar things. So I think this is an international issue. And one thing I'll just note, because I did interview a number of American lawyers that have done work on this issue, and they're facing a lot of pushback from like Democrats and like more liberal people, because they say that everyone should have the right to a trial. So we can't have like slap legislation, for example, which I thought was really interesting. And another reason why I'm apprehensive about the slap legislation and the possibility it's repealed and we could lose that for these like larger political reasons of this, like everyone has the right to a trial arguments. So yeah, it is an issue I've witnessed from all over the world. And there's also, I think I'll stop talking, is this transnational element that I identified with my research, was that because we live in like a world of globalization, people are working all over the world. And so, for example, the woman I started with, she was a young woman doing an apprenticeship in France, didn't know the laws of France, found out after you report to the police in France, you get, not only do you get criminally charged, you also get sued automatically for defamation or false allegations. And it was the Canadian government that extradited her to face these charges. So there's also this like globalization of people being sued in all these different countries, but are residing in Canada, which also speaks to the larger international scope of how do you engage if you don't know the laws of, and like I spoke to Americans that were sued in Canada and thinking that they had, you know, the First Amendment rights, and then, oh, but the harm was caused in Canada. So I think that's a really great entry point to talk about like just how global this issue is beyond just Canadian law as well. Sorry, that was a lot. I'll hand it over to David.
Yeah.
Sorry, that is just such a big issue. I have no idea where to get into that. You know, I wish I had something smart to say to contribute, but I don't. Sorry.
Thank you so much, everyone. Thank you so much to all our panelists and for everyone for coming tonight to Leaf National and Leaf Toronto. I would remind everyone that you can donate to Leaf, and you can also, Mandi put the link to her fundraiser, to the fundraiser that she mentioned here. And absent any technical mishap, this is being recorded, so hopefully should be available to be published. So I already received many messages that people really enjoyed the discussion that we had. And yeah, thank you so much for your contributions tonight, David, Julie, Mandi, and Zelda, who is hopefully sleeping now. Yeah, thank you.
Thanks so much for organizing, Paniz. It was really informative evening.
Yeah.
Thank you.
You put a lot of work into this, Paniz. Thank you very much for doing it.
Thank you.
And thank you for everyone for being here.
Bye.